to Subject to Interpretation, where today we will explore some of the intricacies of legal interpretation. In this episode, we are delving into the transition from state to federal court for interpreters. I'm your host, Maria Ceballos-Wallis, and today we are joined by our esteemed guests, Lorena Devlyn and James Plunkett. Welcome to you both. Before we begin and we let you guys take the floor, I'd like to say a quick disclaimer. The opinions expressed by our guests do not represent by any means those of any district, state courts, or state courts that they have or are currently working with. And that goes for yours truly as well. So welcome, Lorena. She is a federally certified Spanish court interpreter who has worked as a FCCI in border courts in New Mexico and Texas. That would be El Paso and Las Cruces before moving to Austin, Texas, where she currently resides. She's also a master licensed court interpreter by the Texas Judicial Branch Certification Commission, and Lorena graduated from law school in Mexico City. Welcome, Lorena.
Thank you so much, Maria, for having me. It's a pleasure to be here.
Well, it's wonderful to have you. We also have you joined by James Plunkett, who is a federally certified Spanish court interpreter and a nationally recognized interpreter instructor who has worked in Florida's 13th Judicial Circuit and also is the coordinator of interpreting services and language access program for the District of Columbia courts. He is a rater for national credentialing programs for interpreters and holds a bachelor's degree in general social studies from Providence College. And James was raised in Lima, Peru. So I think we've got, Lorena, you're from Mexico. James is from Peru. I'm from Puerto Rico. So we've got, I think, all of the, the regions covered. Welcome, James.
Thank you so much for having me in the program, Maria. Thank you so much.
Well, one of the things that I was looking into when I was preparing for this program was that I wanted to focus a little bit on both the states that you each live in, and just to give people a sense of what the court panorama looks like. So in both Florida and Texas, there are local municipal courts and state courts. Now, this isn't unusual for most states. Florida has 67 county courts and 26 circuit courts, while Texas boasts county courts in all 254 counties and multiple district courts in each county. Now, this is just at the misdemeanor or felony level, but not at the federal level. So additionally, we have both states have 3 federal judicial districts, each with multiple federal district courts serving their respective regions. So that is all to say. We always talk about how the bulk of the work is in state courts. If that is actually the case, then with so much available work in state courts, why would an interpreter choose to work in federal court? And what do you think draws them to the federal system? I'll start with Lorena.
Well, freelance interpreters, at least in Texas, I think they combine both. Most federal courts in the Western District of Texas, which is a district that I primarily work in, have staff interpreters. So there isn't necessarily a lot of work for federal interpreters unless it's a trial where there's going to be team interpreting or any type of longer proceedings. So they do work in federal court, but most licensed court interpreters, because in Texas, the interpreters are not certified, they're licensed. So I think it's the only state where we call ourselves licensed court interpreters. They do a combination of both, civil, criminal at the state level, and of course, federal as well, when there's work available in the federal courts. That's the experience in Texas.
Okay, and what about you, James? Why do you think that interpreters gravitate towards the federal courts?
They gravitate towards it based on the perception that there's a challenge, a bigger challenge than working in state court. And the pay is also a little better in most situations. As freelancers, they, of course, gravitate toward where there's more demand for their services and where they can get a better pay. In fact, some freelancers that I know that work in my division tell me about how much they make per hour, etc., and they make more money in outside court than they do in the courthouse. So I would basically conclude that it's a matter of prestige and challenge to want to work in the federal court setting.
Okay.
And
Well, that
it,
makes a lot of sense because we're always hearing interpreters. Unfortunately, sometimes we end up focusing a little too much on languages on Spanish rather than languages other than Spanish. But Spanish is, of course, the quintessential, the language which seems to have the most use across the board, but also it has all of the testing that is available that's not available to other language. So we end up focusing on Spanish. But when we have a Spanish language interpreter who then says, oh, I've got my state certification or license, just like Lorena said, then, what's next? And what's next is really just federal court, right?
Yeah, I would say yes, until they discover federal court or they think they can handle federal court. So then we have the next obstacle, which is the federal courts have their own standards, and what the main one is, of course, being certified to be able to be placed in a category where you would be called ahead of other interpreters who are at different certification or different levels according to the federal standards.
And it's important to note that interpreters who might be certified or licensed at the state level are called in federal courts, particularly those who are languages other than Spanish and languages, and also Spanish for many places that don't have a large number of federally certified Spanish interpreters. Lorena, well, actually both of you, but let's start with Lorena. You're actually in charge of bringing in interpreters to federal court where you work. Is that correct?
Correct. We brought in, like, just in the last few years, we've had, anything from indigenous language interpreters, many of them. When I worked in the border courts, even more so. Anything from Quiche, Mam, Canjobal, and recently I've had Cantonese, Ukrainian, Korean, so a wide variety of languages, and of course the federal courts has what we call the National Court Interpreter Database. And it's a database with all the interpreters that have previously worked in federal courts. And we have two categories for those: the professionally qualified interpreters, who are interpreters who have passed the State Department exam or are members of the International Association of Conference Interpreters, or another association, which the name just escaped me, maybe James can fill in the blank, the American Association of Language Professionals, I believe. Don't quote me on that one. Those are the professionally qualified interpreters. And then we have the language skilled category, which are interpreters who have experience in federal court and have had certain training. And because there's no certification exam for their language at the federal level, then they can work in federal court. And it's a very complete database that we share with. It's provided by the Administrative Office of the U.S. Courts. And so that's how we look for qualified interpreters who are capable to work in federal court.
So we need to make sure that it's clear that just because there isn't currently a certification for federal court in languages other than Spanish, there have been in the past in Haitian Creole and Navajo, that doesn't mean that there are not other credentials available to professional interpreters, as you have mentioned, interpreters who are with IEC, which is Conference Interpreting Association, interpreters who have passed the State Department exam, and others like that. What about you, James? Do you also currently work with, obviously, interpreters, for Spanish languages, given that you're in, Spanish language, given that you're in Florida, which is a high demand language, but you also work with interpreters of other languages?
Okay, to answer the first part of the question, I do work with freelance interpreters of Spanish when we are teamed up for lengthy proceedings. They come, and they also come on the same day that I'm working in an assignment, because judges schedule their cases not necessarily in unison or in combination with each other's schedules to enable them to just employ me as a staff interpreter, who is the only one in the building, to handle every case in court. So when there's overlap, they call freelancers to handle the demand. In terms of languages that are not Spanish, there are few called into the courthouse for proceedings. We have low demand for languages other than Spanish. And they are all called in and scheduled by a coordinator who's based in the division of Orlando as part of my district.
Okay, so presumably most people start in the state level and then they work their way up and then end up with some kind of mixture of both. I know that's the case for Lorena. You started out in state court, but what about you, James? Did you start out in state court, or is DC a little bit of a mishmash?
Actually, I started in state court before DC. I started
Okay.
in Tampa, Florida at the 13th Judicial Circuit, which encompasses one single county where the city of Tampa is located. I started there as a contractor, maybe for a little less than a year. Then I passed an exam that was the equivalent of the National Center for State Courts exam. And then I became staff for that circuit. I worked there for close to 7 years. And then I moved to the District of Columbia, where I was hired as a coordinator of foreign language interpreters and then the coordinator of interpreting services, because I took on the responsibility of sign language cases. So I'm no stranger to state court level, definitely. I'm no stranger to the high demand, and you're being pulled in all directions to go interpret from one courtroom. And back in the day, you get the vibration of the beeper on your belt, and then you look quickly and you see a number. That's the courtroom you had to go to. So off I went and had to sit there and wait for my case to be called. So I remember one occasion where in one courtroom alone, it was a rainment day, I had 30 people to interpret for. So it was like a revolving door. And I'm sure our listeners would identify with that, can relate to that, because that happens in many busy cities where they need interpreters.
Absolutely. I think a lot of people can identify with that. So Lorena, what were the most challenging aspects for you when you transitioned to federal court interpreting?
I really thought that having passed the federal exam would mean that I would set foot in a federal court and I would just roll with it, right? Well, that is not the case. Passing the federal exam is just the minimum standards required. And so for me, having worked for many years in state court, and then I passed the federal exam, and a month later, I was working in federal courts, it was quite a shock. I think the things that surprised me the most were probably, number one, the speed in federal court. I think that because the judges have a particular script or colloquy that they just say over and over again, sometimes they forget that there's somebody that's being their voice in another language. And so they tend to go 220, 230, 250 words per minute, to where I was not prepared for that. Speed was one. Another thing that was a little bit surprising to me is that preparing for the federal exam, I never studied the terminology that you hear day in and day out in federal court. Terms like departure or a variance or the safety valve or the sentencing guidelines, all these terms that you hear day in and day out. I never studied them for my federal exam, probably because I knew they weren't going to be part of the federal exam. So then when I started working in federal court, first day, I'm like, oh, and what is the difference between a variance and a departure, right? And how do I interpret this? So that to me was, it was, trial by fire to learn on the go. And so that was another aspect, that working from state to federal, I think I was, I don't want to say unprepared, but it was certainly a wake-up call that I still needed to study a lot, to learn a lot, and to prepare, and I still do every day. So I think those were the two biggest differences.
Well, I think that any interpreter who takes her craft seriously understands that we are in a continuous learning process, which is why our slogan here for Subject to Interpretation is never stop learning. So what about you, James? First of all, I'm not going to quiz you on the difference between a variance and What was the other one?
Departure.
A
And
departure.
departure. Thank you very much. I should know this myself. So there you go. I'm not going to quiz you on the difference between a variance and a departure, but I am going to ask you, what were the things that, called out to you when you made that transition, when you, went into those very quiet courtrooms, with, people who are, kind of, speaking in hushed tones, and somehow or another, it seems almost like a cathedral when you walk into one of these courtrooms versus what, the state courts or traffic court or municipal court, which are just, sometimes they can be a free-for-all.
Well, definitely all of the above for what Lorena said. I could perfectly identify with that. I went through the same experience. I had interpreted in federal court maybe twice perhaps, or maybe thrice. When I lived in Tampa the first time around, I had been already federally certified, but I had my full-time employment at the 13th Judicial. I did a few hearings, like an initial appearance when they bring a defendant in for the first time. And I was hired once as an interpreter for a government witness. So those experiences were different. I felt a huge degree of responsibility, but in the end, it boiled down to the context involved in the type of crimes committed at a larger scale that involved interstate commerce and whatnot. So it was also a learning curve in terms of vocabulary. I also had a situation where my second week into the job, a full-time job here in federal court, I really struggled interpreting at that speed of light that Lorena mentioned for this particular judge, because she was reading from her script during a sentencing hearing, and I just couldn't keep up. And I had to raise my hand and stop the proceeding. And the judge looked a little bit bothered by it. And then she said, "You should know about this." And I was puzzled because it was only my second appearance before her. It turns out the courtroom deputy came by later and said, "No, don't you worry. I told the judge that she was confused. She was confusing me with another freelance interpreter who was kind of thin complexion, and she had another type of expectation. So she cut me a break, and immediately I started digging into vocabulary and terms to really make sure that I understood the difference between departure and variance and other terms that were unique to the federal court system. But yes, it is more ceremonious. The courtrooms don't have as many people as part of the audience. And so you feel there's like a huge place, versus a state court setting that the courtroom may be perhaps as large, but just with a lot of people. So it doesn't seem the same. So it's more ceremonious, more subdued, more solemn.
So adding to those differences, Lorena, what struck you the most when you started entering the federal realm?
Another thing that really struck me is when I started working in federal court, I started working in the border courts. If you really want to experience what it's like to work in federal court, go to a border court, right? So to me, like James was saying, that sometimes in county courts, there might be 30 people you're interpreting, it's a revolving door of people. One of my first initial appearances, we had 138 people for initial appearances because they were prosecuting at that point what in federal court we call 1335s, which are illegal entries. And so interpreting in groups of 8, so picture 138 people in groups of 8, it's it takes 2 or 3 hours, right? Fortunately, with a great team interpreting always in federal court, that's always been my experience, and so I got through it. But the volume was really shocking to me. Another thing that was different, and it still is when I interpret in federal court, is when you're interpreting on the witness stand, it's kind of a question and answer, so it's short consecutive. In my experience in federal court is that during sentencing hearings, the judge sometimes allows, or typically allows, at least in the Western District of Texas, the defendant to allocute. And these allocutions are very important, and I take my role as the interpreter for this person who's asking for mercy for the court, I take it very seriously. So I try not to interrupt. And so it can be long. It can be very long. And so I was surprised how much I was going to be doing longer consecutive than I'd done before. And of course, that meant brushing up on my note-taking skills and knowing when to politely um, interrupt, because you want to be the interpreter and not the interrupter, but sometimes you have to. And so that was another big difference that I found between state court and federal court, because previously I had only done witness, when I interpret at the witness stand, it's typically the attorneys, right? That either they object or they pause or they interrupt the witness. But this was a different ballgame for me. And I feel like I'm still trying to perfect the skill of long consecutive without interrupting too much. And it's a challenge.
I'm sure it is. And for our listeners and viewers who work in medical settings, educational settings, and allocution is essentially a legalese word for a presentation before the judge of asking for mercy or telling the judge the opportunity the defendant has to speak to the judge and give them some context, some color as to who they are and how they may have reacted to what they did and how they feel about what they did, so that this can be considered during sentencing. And it may be something that can be useful in the variance or the departure, maybe.
Correct.
So James, tell me, you hinted to that a little bit earlier. How did you overcome this learning curve, the speed that that you found yourself in? Obviously, I've seen that you recently are teaching, interpreting for, fast speakers. So you must have sat down and said, what can I do so that I can figure this out and eventually maybe share it with others?
It's kind of like accidental research, because I've always been keen on research on interpreting skills and the theory of it, the linguists that research interpreters. As a side note, there's not enough information yet researched in terms of court interpreting. There's books that are published. However, in terms of research, where you compare the research with conference interpreters and the studies done from one language to another, and so many subjects participate in this study about interpreting in a conference, etc., I don't see that in court interpreting. So it's always sent me to research and find out if there's anything like that I could learn from. And with my background as a teacher, that I could also share that in an educational and pedagogical format with people. So I dug into that. I started looking for information, and then I discovered, things that are kind of common denominators with other domains like conference interpreting and court interpreting, saying speed, understanding, anticipation, different parts of the skill set for simultaneous interpreting, as well as consecutive and sight translation. So upon looking at those, I realized, well, there are practical things that any interpreter should do. Start slowly and then work your way up in speed. So that's one factor. Fortunately for me, not all judges are created equal. So when I had a type of hearing in federal court called change of plea hearing, there are judges who speak more slowly than others, even though they all go by their scripts. There are some variations, but according to their laws and the precepts of the proceedings, they have to cover many points. And all those points are covered sometimes in their own words, there's overlap, etc. So I took advantage of that. Coming to learn and understand the words, the terms that they used, I was prepared later for faster speaking judges. Now, one other thing that I learned as I did my research was in terms of discourse, analyzing the discourse. And that was thanks to, in fact, a request by the National Association of Judiciary Interpreters and Translators. With Agustin de la Mora, we were asked to prepare a presentation on discourse analysis. And it was a new concept for us. So we researched the topic. We learned that, yes, this happens in court. So we decided, well, how can we apply it to court? Not just to analyzing a text or groups of texts. Analyzing what is typical in court settings, then we discovered, hey, I can be better focused on how the speakers are going to speak, how a judge will talk to the attorneys, how an attorney will ask questions of a witness in direct examination, in other occasions on cross-examination, how attorneys speak to the jury, how, with what purpose. All of that helped me be more focused, better focused in terms of what I can expect the attorneys or the judges to say as they speak. Where are they going with this speech or with this narration or a story, etc. So that made it easier for me to be able to handle the speed because I knew kind of where they were going. And then I adjusted my terms accordingly. So that's also another factor, the vocabulary that you use. You really need to accumulate a rich vocabulary. Mine is not super rich yet. I'm always learning. So you always look for the more syllable friendly, syllable economical speech. In case of Spanish, Spanish uses many syllables for a word that in English you typically have monosyllables. And so English seems to be faster, and they're saying many more words in a particular period of time. But in Spanish, I have to speak faster because I have to fit it all into a limited amount of time. So all these little things I learned to appreciate through research and through experience.
Now, Lorena, James has given us a little bit of insight into his thought process when he prepares for his work, as well as when he prepares to teach others. I know that you're also an instructor, and one of the things that I believe you're very interested in is this idea that interpreters should have access to court proceedings, real court proceedings, and interpreters and more senior or more seasoned interpreters in order to actually really get a real life, a life type of experience. Is that right?
Yes. What I tell my students is that nothing that I teach them in class will ever compare to going to the courthouse and sitting in the back and try to interpret the whole proceeding. And I always invite my students to come visit the state court or the federal court. And of course, I always let them know that these proceedings, most of them are public. Unless they're sealed, they're public. And so come observe, come sit down and observe. And that way they get a real sense not only of the terminology and the speed that they're going to be exposed to, but also basic things like where to sit, how to dress, who is who, where's the defense table, the prosecutor's table. Until you go and you sit and you experience it and you live it, no matter how many state or federal exams you've passed, you do not know what it's like. So I always encourage them to come. I believe it's an invaluable tool to prepare for state exams and federal exams, and then further on to be ready for the day that you're really in court interpreting, and then you know how it works. You know where to go, where to sit. You're ready for the speed. You might even already have seen the judges or heard the judges, so you're better prepared. And so I think shadowing, visiting these courtrooms is a great experience, and I encourage all my students to do it.
And I know that James was shaking his head in agreement, so I think you've got a little bit to say about this as well, right?
I recommend almost practically the same thing. I add a little bit to that. I've being a welcoming body there I remember in DC courts or here in the federal courts, telling people go to the proceedings, sit there and listen. What I also ask them to do is to sit in a busy courtroom like the one I mentioned earlier and pay attention to the similarities of the vocabulary and the terms and the discourse that is going on between attorneys and judges, to try to detect the common denominators and take notes, not just attend an event passively, but very actively take notes. If you're in the learning part, write down what the judge is saying to the attorney, what the judge is saying to the defendant, how the defendant is answering, how the attorney is answering. So all these things have to become a common set of expressions, a set of common expressions. And to learn those, to absorb them and come up with a translation for them into their non-English language so that they can practice them. And next time they come back, they are able to whisper, interpret in the back of the room, like Lorena pointed out. That's how they get real practice, not just recordings that may be out there commercially.
Now, we always hear that one of the things that interpreters should do is ask for information about the case, ask, whenever possible. It's not always possible, access to, case files, police report, depending on where they are and how, their relationship with the people that they're working with and the clerk and the courts. But I found it very interesting when I started working in federal court, the fact that staff interpreters and also freelance interpreters have access to certain documents that are sent to them in advance, or that they can access, through the database and get a sense of what is going on in the case. What is the pre-sentence report say about the person's level of education or substance abuse history or criminal history? What does the pre-trial investigation report recommend? And there's other documents which are filed, which interpreters hopefully have regular access to in federal courts, which I don't believe it is really something that interpreters have access to as much in other courts. Can we talk about that a little bit, and the importance and how this enhances the ability of the interpreter to be present? Go ahead, James.
Okay, my experience in state court, the first part of my career as a court interpreter in Tampa, we didn't really know too much about the case when we went there. We hardly ever thought about asking for the case file from the courtroom clerk to look at that information. When I went to DC, the things changed a little bit, because there was somebody who was there already as a coordinator of sign language interpreters, and he taught me, yes, you can actually ask the courtroom clerk to share the folder with you that has the police report and other documentation regarding the case, so you can glance it before the actual proceeding. That helped tremendously. But when I became more experienced as a coordinator working with the foreign language interpreters, including Spanish, I realized, I don't have to go into a guessing game or send my interpreters to an assignment cold turkey, if you will. I have the capability, I have the access through the system as an employee to print out the police report and give it to my interpreter before they went to court. I asked them, of course, be discreet, don't take it with you to the courtroom, read it over here and leave it over here. So they already had an idea as to who, what, when, and where, and how of the case. So they went there informed. Now, in terms of federal court situations, I know that the coordinator sometimes sends the information about the case that they have to the contract interpreter that is assigned to the case. So they have a good idea as to what might happen. Of course, it's depending on the type of proceeding, they're giving enough information. I know that online, the public in general has access to some of the court documents that are made public, available to the public, except, like Lorena said earlier, sealed documents for sealed proceedings. So the public in general has access to it, and there's a website. I don't know if you might mention it. I don't know if this is the time to mention it.
Yeah, let's go ahead. Go ahead and mention it.
There's www.pacer, P as in Peter, ACER.gov. And I believe one has to subscribe to it. I don't know if they have to pay something. And they have access to a lot of court documents, a lot of case information, which judge is doing what, etc. Also, some local federal court websites have kind of like another type of access, but not necessarily to documents. They may have some standard forms that the people have access to. Sometimes judges publish the script of their proceedings for change of plea hearings. And that's long ago I came across one of them, and each judge has their own script for a change of plea proceeding. So that was an interesting gem that I found there. So it depends on from district to district. The access to resources changes, of course, but that information is available unless, of course, it's a special situation where the documents are sealed from the public.
So it sounds like you have to prepare for everything and expect anything, right?
Yeah, yes, indeed. But as long as you have access to that information, definitely will make a big difference. There will be no surprises when you actually have to work in the courtroom.
Lorena, does it work the same way in your court? And in your experience, have you found that the availability of this information can enhance your ability to provide an accurate and effective interpretation?
Absolutely. The more information you have, the more smoothly everything will be, and the more invisible you will be as an interpreter in the process, which is the goal, right? Things, just simple things like, the names of the attorneys, the names of the defendants. Sometimes it could be, names that are hard to pronounce. If you have all that in written form, then or if they're going to mention certain case law or certain laws, and and as we've talked about before, in federal court we love to use the 11C1D agreement or the 1330, the 3553 factors and things. And so when it's a series of names and numbers, if you've read them before, if you've seen them before, the short-term memory kicks in, and so it is a lot easier. And I even in state court, when I was in state court, like as James mentioned, when I was working there as a staff interpreter in state court, I would always share that information with the freelance interpreters, and they were always very appreciative. And also staff interpreters in federal court also work through a program that I know James is familiar with called the TIP program, the Telephonic Interpreting Program, where staff interpreters or interpreters for other languages interpret for other districts. And for those type of cases, when it's remote interpreting, especially over the phone, it is so important to have that information because you don't know who's talking. You can't see anybody. It's over the phone. So super important, even more so to have as much information ahead of time. And typically the courtroom deputies or clerks, as they're called in state court, are very generous sharing that information. And in my experience, staff interpreters and contracts interpreters are always very careful with that information as well.
Did you want to add something to that, James?
No, I've had the same experience as Lorena has had.
So let's talk a little bit about some experiences. For example, so experience and experiences. My story is that when I went to FIU and took their interpreting program as long time ago, I won't say when, but there was a component in this 2-year program that was actually an internship. It was I think it was a 3-month internship. And I spent 3 months going, or once a week to one of the local courts and observing. I got to walk around with interpreters. I got to observe. I got to learn from them, essentially get the lay of the land, to feel comfortable in the environment with the courtroom, so that when I walked into that next courtroom by myself, I actually knew who was who, and I didn't get what I like to call the deer in the headlights, where you got. So, what advice do you have for aspiring federal court interpreters regarding seeking internships or relevant experiences that they can, so they start to feel more comfortable in this kind of environment? James.
I don't know of any internship program sponsored by the federal courts for court interpreters. Maybe Lorena does. I don't know.
I don't know that there's any, but what I do recommend interpreters that are interested in gaining experience in federal court, because obviously they're not certified, they can't work in the courts, but they can assist or even shadow attorney-client conferences, attorney-client conversations, conferences, and jail visits, things of that nature. So that's good practice. They can go, because it's not in court, they can probably do some interpreting. A lot of these attorneys have paralegals who are bilingual, who could be great mentors, and who could, make sure that the interpreter, if the aspiring interpreter, if he or she is trying to learn, maybe do some portions and verify that what's been interpreted is being correctly interpreted, and with the attorney present, of course. So that would be a way. But as James says, I don't think there's any internship programs for court interpreters, which is something that maybe we should all look into and perhaps bring it up, because I think it would be great. What a great experience. I wish I would have had that opportunity.
The alternative is do something more informal, but it would be up to each district or each coordinator to allow the staff interpreter to use their time to assist aspiring interpreters by doing something similar to an internship. I haven't had that experience in federal court, although some people have come to me, oh, I would like to follow you, etc., shadow you, and I've allowed it to happen. So it has to be done in coordination, maybe just to be a little more formal about it. And there has to be a purpose in the shadowing, not just shadow me at different proceedings. No, there has to be a step by step, I think. And I've done that when I've mentored other people in state court settings. So there should be a little system involved so that the observer can get a more complete sense of what is from step A to step Z, if you will, to get a well-rounded education in practice as to what court interpreting is in the federal courts.
Well, James, I think you used a key word there, mentoring. And what I found interesting in my own journey was that I spent, quite a number of days observing federal court from from the gallery. And that's one thing, but it really wasn't until I had the opportunity to sit next to an interpreter who was working, who showed me how to, this is what we do with the equipment. This is how we prepare it. This is what we have to do. This is how we work with the microphone when we are doing consecutive. This is what we do with all these different things. When I actually got a chance to see them at work, the little mechanical things that they are doing in addition to interpreting, then I really got a better sense of what multitasking skills I was going to have to develop. That would be the first thing. The other thing I want to give a shout out to NAGIT. I don't know if any of you have been to the NAGIT courthouse tours, but when NAGIT has its conference, there's often a visit to a local courthouse. Sometimes it's state, sometimes it's federal. And a couple of years ago, we did do one to federal court in Las Vegas. And that to me was with a tour with the marshals and everything. And that was, to me, that was a really, really good opportunity to get a sense of what was going on behind the scenes of the courthouse in addition to the courtroom. I want to switch topics here, although I did want to do that little shout out to NAGIT because it's really important. And I think that our listeners and our viewers should, keep an eye out on, when the next conference is and what opportunities they might have to do something like this. But I want to switch gears just a little bit. Let's start with you, Lorena. In what ways did your preparation for the federal court interpreter test adequately prepare you to work in federal court? And where did it fall short? And James, I want you to also pick up on that as soon as Lorena's done.
Well, I think everybody is terrified of that exam. You hear about the passing rate and everything. So I know many of us, most of us spent a year or years preparing, right? And so, like I mentioned before, I think I prepared a lot for the terminology that I thought would be included in the federal exam. I really focused on that. And then when it came to time to interpret in federal court, I realized that a lot of that terminology wasn't there. But again, it forced me not only to memorize, and I don't even think it's memorizing. What most of us do to prepare is understanding what these terms mean. So know the legal terminology, of course, in English and Spanish, but know what it means, because at the end of the day, if there isn't an equivalent in that target language, if you know the meaning, you can still interpret, right? Still deliver the message. So that's how I prepared. In ways that I was unprepared, again, was I think the terminology that I didn't study because I didn't know it even existed. The very particular federal terms that we use day in and day out, and then another thing, the equipment, for example, when you're preparing for the court interpreting exam, you're not really realizing that you're going to be using, in most federal courts, professional court interpreting equipment, consoles and microphones and things. In my state courts, there's no such thing as that, right? It's mostly chuchotage, still the old way. And so I was not prepared after the exam to learn how to operate these consoles and learn how to put my headset and control the volume, and which one's the mute button, which one's the cough button, which is a yellow button that goes to the PA. So all those are things that, again, with great mentors, once you start working in federal court, your team interpreter, the staff interpreter, other contract interpreters who have been doing it for years are very generous with their knowledge. But yes, I think the federal exam, it's just literally the piece of paper that allows you to set foot in the court and do what you love to do, right? Which is to interpret and language access and all these things, but it by no means adequately reflects what you're going to need in terms of also nerves of steel once you're in there. So that was my experience.
Absolutely.
I agree with what Lorena just said, because taking an exam exposes you to some a glimpse of what the reality of court is in the federal court system, because you are tested on some aspects of a court case, for example, be it a side translation, be it the two types of simultaneous interpreting sections, plus the consecutive. Coming from the state court experience, I was familiar with the format of consecutive. I was familiar with the opening statements. I was familiar with the interrogation of an expert witness for all those different types of modes. And I'm familiar, yes, with the side translation of documents, but it was a different level. It was different type of vocabulary, different reality, different types of crimes that occurred in the federal law versus the state court level. So for that, I was unprepared when I went to a real courtroom setting after being federally certified. And then again, back in the day, as I mentioned earlier, I had done only maybe 3 proceedings in federal court as a freelancer, if you will, all the while being a staff interpreter in state court. So when I would go back to my state court employment, I would think, wow, that was different. Very formal, and I didn't know what to expect because there was nobody there to teach you, to guide you. So that was a big, big mystery for me. Then when I came from the DC courts, which was kind of like a hybrid of state and federal a little bit, I had some notions of the vocabulary, luckily for me. When I came to federal court here in Tampa, though, the vocabulary was different. That some of the proceedings sounded different. It's like you're eating pasta, but one type of pasta has one taste and the other type of pasta, even though it's pasta, has a different taste. So the pasta, when they tasted different. That's the same experience I had between state court situations and federal court situations. So it took adjustment, and the condiments, the vocabulary, was what made the difference. I had to learn how to use it so I could perform well in each particular setting. So yes, like Lorena said, you go from an artificial situation like an exam into reality. There are big differences, and you need to have a helping hand to guide you through that so you don't come into a little shock.
Now, I also think that there's another big difference in how interpreters are employed in the federal courts with regards to interpreters being hired for the prosecution to interpret for witnesses. And then there's the staff interpreters who have a certain role and interpret for certain proceedings, but not for others. Can we talk a little bit about that? Because that to me was a little bit of a surprise coming from a state court system. Lorena, can you tell me a little bit about that first? And then James, you can chime in.
Yeah. So in federal court, non-English speaking defendants are by law required to have an interpreter in cases instituted by the U.S. government, right? So it's criminal cases, not civil cases, unless it's a civil case instituted by the U.S. government, which is very unusual. So the staff interpreters or the interpreters that the court clerk hires are going to be exclusively for that defendant. If there is a witness for the prosecution, the U.S. Attorney's Office, that interpreter will be hired separately by the U.S. Attorney's Office. Another big difference is that federal interpreters have certain rates that are, those are set by the AO for federal certified court interpreters. The U.S. Attorney's Office does not. So a lot of federal certified interpreters, if there's a trial, for example, perhaps they prefer to work for the U.S. Attorney's Office because the U.S. Attorney's Office can can negotiate the rates with them versus the federal courts who have a set rate. It's half day or full day, but it is very rare, at least in the 2 districts that I've worked with, that a staff interpreter or a contract interpreter that has been hired by the court would then the next day in a, let's say, week-long trial would be the interpreter for the prosecution. I know that's different in many state courts, including state courts in Texas, where I worked before. I think the lines are more, defined in federal court than in state court, unless James has a different experience in Florida or DC.
the same experience with Florida.
Mhm.
That exactly what Lorena said. Interpreters that work for the prosecution or the government negotiate the rates with the hiring entity. In federal court, it's all set by law. Mhm.
Now, interpreters who want to know more about the rates and their fee structure in federal court, that information is actually available on the websites. And interpreters have been freelance interpreters in particular, have been very vocal in the last couple of years to try and have that rate, whether it's a half a day or full day rate, keep up with the cost of living and with the inflation that we have. One positive thing about that is that, you know, the more success that federal interpreters have with maintaining a living wage and, you know, with the cost of living and inflation, then that also trickles down to interpreters who are working in state courts and in other type of courts. At least that has been my experience. Any thoughts on that? It's a slightly off topic, but I just think it's interesting. I think interpreters would want to know a little bit of that.
I've had a lot of experience with interpreters not wanting to come to work to a court setting twice or maybe 3 times in my experience at the DC courts, where everybody likes each other. I treated them nicely. They were nice to me, etc. However, business is business. And there were occasions where the court budget did not contemplate an increase to the rates that they normally pay to the interpreters for the services received. That forced the interpreters to write a letter or two to the administration and ask that the rates be increased in deference to inflation and the rate of cost of living and all that. When the courts failed to act quickly enough to that request, then interpreters together as I would say as a unit, not as a union, but as a unit of colleagues, decided I'm not going to work for that court system, not paying me what I think I deserve, or I need to pay my food on the table, or I will go somewhere else where I can get paid better. So they stopped coming to work to the courthouse, and that happened to me 2 or 3 times until the court system came to the realization we need to pay them more. If not, we're going to lose interpreters, and we will get unqualified interpreters to cover the system, or we'll have to pay a lot more to an office, to a department, to provide us their interpreters who are not always federally certified. At the time in DC courts, our preference was to hire first federally certified interpreters and then state court certified interpreters, kind of like mimicking what the federal court system was doing. Remember, DC courts is not a federal court system. There's a U.S. District Court in DC, and there's our local court of jurisdiction in the District of Columbia. So that was one reality we've had. And then recently, we were exposed to another letter like that sent by federally certified interpreters of Spanish sent to the United States Administrative Office of the Courts, requesting that the USAO revisit its payment structure for freelance interpreters. And after that letter, it prompted studies and research. I'm not part of that, but the bottom line is that the rate was increased as of January of 2023, I believe. Lorena, you could correct me if I'm wrong. So that
Correct.
was my experience.
Yeah, and to that, I will also add that with that increase also came an increase for professionally qualified and language skilled interpreters for languages other than Spanish. So, so when the federal certified interpreters as a unit, like James said, I'll ask for this pay raise, then that also helped the interpreters for languages other than Spanish because those rates went up as well. So I think, yeah, I believe it was 2023. And I guess they're and maybe in some districts they're compensated at the same level as state interpreters, and maybe in other districts you know, they still get paid more. I know, for example, DC, the interpreters that work for the State Department are still getting paid more than federally certified court interpreters, for example. So I guess it depends on the district.
And to make sure that everybody knows that we're all on the same page, the AO is the Administrative Office of the Courts, correct?
Correct. Yeah.
And they are the ones that set the rates for interpreters on a federal level.
All
yes.
Right. And also by at the same time, there are administrative office of courts at the state level too.
Okay, and those are offices that are often charged with hiring interpreters for the cases at the state level, or at least overseeing them.
They oversee the programs, is my experience. The ones that hire the interpreters for court proceedings are the local courts of jurisdiction, like circuit courts or county courts, whatever they may be called in different states in the country.
And I was going to add the Texas Office of Court Administration, which is the one in Texas, does not set rates for interpreters. Those are set by the district courts or the county courts at the state level.
So something that interpreters should know is that some states have what they call unified, their unified court systems, and those states would probably definitely have the rates that might be used across the state. But when you don't have a unified system, then the county courts, the state courts, they all set their own rates according to demand and supply and demand, among other things. Now, with regards to opportunities in federal court, they're also, depending on the state, depending on the district, there's opportunities to work for the public defender's office, to go with attorneys to client visits at jails. There's obviously the opportunity to work with the prosecution, and then there's also the freelance work and staff work to work with defendants. Have I missed anything? I mean, it sounds like an interpreter could be pretty busy if they are in a district where there's a lot of work. James?
In the U.S. court system, there are offices that are staffed by employees of the federal court system, like the United States Probation Office, that also has a pretrial services agency. Some locations are very, very privileged, if you will, to have bilingual staff, primarily for Spanish. Who knows, there may be other bilingual staff, English and other languages. They conduct interviews of detainees and or defendants to try to get information for special reports that go to the judge and to prosecutor and defense attorney for decisions later in court proceedings. They may need interpreters. I've provided interpreting services to U.S. probation officers who needed to interview the defendants themselves or call relatives or friends to corroborate information given by the defendant as part of the processing of a pre-sentence investigation report. So those requests can come up, services for those agencies as well. I don't know about medical, evaluations, etc. I have not had that experience in federal court. And I don't know what other offices could be there that need the services of interpreters in the federal system. Maybe Lorena can complement to that.
As a staff interpreter in certain districts, as a courtesy to the defense attorneys or to the probation or pretrial offices, if the staff interpreter is available, then staff interpreter could assist with those. And other districts, I know, for example, California, the Southern District of California, their office has a memorandum of understanding with these other offices, pretrial and probation. So the staff interpreters or the contracts interpreters that they hire will also assist these offices. So I guess it depends on the district, but in my case, in the Western District of Texas, again, like James said, a lot of these pretrial officers and probation officers and even defense attorneys are bilingual. So most of the time they interpret themselves, right? They wear both hats, whether it's, I'm not going to go into if that's a good thing or not, but that's what happens sometimes. Yeah.
And it's important to note that depending on the demographic and the language composition of each state and each series of courts, you're going to have obviously a different demographic of attorneys and of staff in probation and in the other departments that who may or may not be able to circumvent the need for an interpreter. Certainly, we have obviously very, very large Hispanic population all across the United States, and certain states which you both represent, Florida and Texas, among others, have high numbers of Spanish-speaking populations, which would include employees and attorneys, etc. But that doesn't mean that interpreters who work in other languages would not have the benefit of having different opportunities for work, because in the end, all of these roles have to be filled, right?
Indeed. The opportunities obviously are fewer for languages other than Spanish, definitely, statistically, already proven. I believe, I don't know, Lorena, you can correct me if I'm wrong, but I think like 93% of the proceedings held in federal courts are for Spanish, and the 7% that remains is for the other languages. I don't know, maybe I'm off with my stats.
Yes, that is correct. And the other 7% varies a lot depending on the worldwide political situation. Like recently we've seen a lot more Haitian Creole, for example, or Ukrainian. So that varies, but yes, correct. It's more than 90% of the cases for non-English speakers in federal court are Spanish.
Mm-hmm.
So, Lorena, looking back, what do you wish you had known before starting as a federal court interpreter? What do you share with your students? What nuggets of, little gold nuggets do you have for us?
Gold nuggets. Well, I think one of the biggest things, and I tell these to my students all the time, is being a federally certified interpreter is not just another feather in your hat. That's not what it is. It's just having the minimum knowledge and interpretation skills and terminology and vocabulary and understanding of the legal world at the federal level to be able to do your work, right? So I think I ate humble pie when I started working in federal court because I thought, ooh, I have this exam, I'm ready to go. Also, another thing is that if you only work in federal court, you will, in a way, just pigeonhole yourself, right? Because the type of cases are more limited. It's a lot of immigration, a lot of drug cases. So all the experience you had before working in state court, if you're never going to step foot in the state court again, is really going to help you. You did all sorts of cases, from DWIs to sexual assault to anything like that. And once you're in federal court, it's a more narrow world. It's immigration, it's big drug cases. So I'm not going to say I don't work in state court anymore. I only work in federal court. And I'm not going to say I miss certain aspects of state court, but sometimes I do think, wow, if I were to show up in state court and it's let's say an arson case, would I even remember that terminology? Because I've been doing the same thing day in and day out. So for those who are freelancers, a combination of both, I think it's ideal. And for those who are staff interpreters or contract interpreters who only work in federal court, we need to make sure we don't get lazy, right? Continue to attend conferences, continuing education courses, training, so that even though what we do can be repetitive, because of the type of cases and things like that, that we are always on our toes, always learning, and of course, always never lose track of the fact that we are there for language access, and that's our role. And I take that responsibility very seriously. And so I always try to do the best job that I can. So.
What about you, James? Looking back, what do you wish you had known before, if anything?
I wish I had known more about the system and how it worked, what it looked like, what it felt like. So the lesson to share with others who are considering going to work in federal court is make a trip to the federal courthouse. Try also, you can let your fingers do the walking around or the research, but go to a website of a federal court system, division, etc., and find out what type of hearings are coming up. Look for little hints, like if you look at the judge's schedule, not all of the judges post it, but you go to the judge's schedule during the week or next week and next month, and look for cases that have CR inscribed on the case number. That means criminal. If you're interested in civil cases, it's like CA or CV, I believe it is, and you can go to that type of proceeding if that's what you like. But our bread and butter for interpreters is typically criminal cases, like Lorena mentioned earlier, is U.S. against defendants typically. That's the cases where we get called as interpreters. So go explore, go to the courthouses, get into the courtroom. Oh, most of the cases, most of the times they don't let you in with your cell phone. So be prepared to leave it in your car. Go with pen and paper and go explore, listen, repeat, repeat the proceedings. Go again several times so you're really imbued with all the vocabulary, all the proceedings, so it's familiar to you. The next time you're hired, you will be more or less familiar because you have to then interpret. It will be the new experience there, but at least you're familiar with the surroundings, with the setting, and you will not be surprised and shocked. So that's one thing that I wish I had learned.
So that our viewers and our listeners are not completely, left, scared that, this is too much to handle and that this is just, too much of an endeavor. Let's start with you, Lorena, first. What transferable skills did you find valuable in your transition? And what advice do you have for interpreters making a similar transition, or at least trying to add this new experience into their toolkit?
Well, I think, of course, having prepared for the state exam and having interpreted at the state level for a couple of years, that's probably the experience of most of us. Then the transfer of skills, of course, is how to interpret in all three modes: sight, consecutive, simultaneous. Those will transfer. It might be a little bit faster at the federal level, but it doesn't mean that we can't do it. It's just a little bit of more training, right? The brain is a muscle. We train that muscle. We can go faster up to a certain degree. So everything that we learned, and experience at the state level, it's the same, just a little bit faster with probably a little bit different terminology, but it is the same. And I think that mostly, I don't think anybody goes, who's an interpreter doesn't enjoy what they're doing, right? So if you love what you're doing, that's a transferable skill, whether you're in state court or in federal court. And to me, working, showing work every day, it is such an honor. I love what I do, and that's why I try to do it well every day. And so I think my enthusiasm, or anybody's enthusiasm, is a transferable skill, right? So I really think that people are more intimidated by this concept of the federal exam and being a federal interpreter. We are all the same, right? Just some of us, have passed the exam, and the rest of us will. And so I don't want to scare people off. And like what I tell my students, most of the students I prepare, they're trying to pass the state exam initially. And I always tell them, if I could do it, you can do it. That's it. I don't have any special magic skills that you don't have. It's practice and it's passion a little bit, and purpose.
Wonderful. Thank you. What about you, James?
Well, it's the transferable skills that the same as Lorena said. In the ability, the skills, the interpreting sight, translations, simultaneous interpreting, and consecutive, all those would come with you. It will be a good transition into the federal system, no problem. It's just, of course, speed is an issue. The dislike of judges sometimes to be interrupted all the time if somebody interrupts them because they cannot keep up. So yes, you have to really prepare, be fit for a next level up. But of course, it's not something that should be scaring you completely, that you don't want to do it because, oh my gosh, federal court. The people that are in the courtroom, from the judge to the security officer, all are human beings, just like we are. So that should not make us intimidated. It's just a change of flavors, change of clothes, if you will. And it's just changing a little bit of the pace. But if you already have that experience of working in state court, the principles are there, from arraignment to sentencing. So all that is there also in federal court. So don't be surprised. You will not be surprised by that. So take it as, oh yeah, that's familiar to me. I don't have to be intimidated, or I don't have to learn that again. This is already familiar territory to you. So don't feel intimidated about that. That's what I would suggest.
Well, thank you so very much, James. Thank you, Lorena, for joining us here today on Subject to Interpretation and sharing your insights and expertise with our interpreters and our audience. I am sure that they have gotten as much out of this as I have myself from listening to both of you. So thank you very much.
Thank you so much, Maria.
Thank you for inviting us, Maria.
And to our viewers and listeners, we hope you've enjoyed this episode of Subject to Interpretation. Please visit the De La Mora Interpretation Institute at delamorainstitute.com and sign up for our newsletter so that you can stay up to date with our new courses and events. And we'd, of course, love to receive your comments or suggestions for future episodes at podcast@De La Mora Institute. Thanks for joining us, and never stop learning.